And sometimes you wait like 5 minutes. It takes a minute or two, and you be like, okay, I got to go. I got to get back to hitting record once the judge come on. Okay. Now, this is where the two voices come in. Remember now? Uh-huh. Oh, it's muted. Okay. Now I go back to my main session, just right here. Okay. Got it. Okay. And then just wait on her. So them two that's already done, that's all I need. That's right. No, I'm just talking to myself, getting it now. That when I go to that options, them two that's already did, that's all I need. Mm-hmm.
All right, everyone. The time is now 2 p.m. Let's go. This is the state expedited accusations calendar in the state court of Fulton County, Georgia. I'm Judge Melanie Williams. Today, we will address cases where individuals have been recently arrested, but the cases have already been formally accused by the Solicitor General of Fulton County. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney. When I ask you if you understand your rights, those are the rights to which I am referring. All participants, this particular proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch this. Those who receive a surety bond or a cash bond will be reset to the state all-purpose calendar. Ms. Bridgewater, what is my reset date for the state all-purpose? You're muted.
Sorry about that, everyone. It will be January the 10th, 2023.
All right, so if you receive a surety or cash bond, that's the date to which you will be reset. Those who receive a signature bond will be reset further notice. All right, who do we have first?
Good afternoon, Judge. This is going to be
Afternoon.
position number 1, Mr. Allison.
Okay, Mr. Allison, your case is 22 CR 008535F. You're charged with criminal trespass with the offense date of the 27th of December. Do you understand your rights?
Yes, ma'am.
Thank you. Mr. Howard, can I have the history, please?
Second arrest, October DUI.
All right, thank you. Ms. Sari?
Yes, Your Honor, I apologize. I'm just pulling this up. This incident took place at 1240 Timberline, that's Timberline Place in Alpharetta. Officers responded to this incident location and spoke with the victim, whose name is Melina, that's Melina, same last name as the defendant. She stated that she and the defendant are in the process of getting a divorce. On this incident, the defendant grabbed the victim's phone and threw it against the wall. And when officers did respond, they spoke with the defendant, who did admit to damaging the wall and showed them the damage to the wall. We've heard from pretrial regarding the open DUI that's in another county. So this defendant does present a risk of reoffending, as well as a risk of intimidating this victim. We are asking for a $2,000 surety bond, no further violent contact with the victim, and that's only due to the fact that they are pending a divorce, a stay away from the incident location, 1-day anger awareness, and no drugs, alcohol, or weapons.
All right, thank you. Ms. Melnick?
Good morning, Your Honor, and happy holidays.
Happy holidays.
Your Honor, this is the, as the record has reflected, this is the first any type of violent incident that my client has in his entire life. He works for Scientific Games. I did ask him if he had another place to go. He said that he could go live in the at least East Atlanta area with his brother, Zach, because I told him that probably returning to the residence without an escort would probably not be an option. He does work for Scientific Games. Because he does work off his computers, I would ask to have a member of his, what?
Someone's unmuted. Continue, Ms. Melnick.
I'm sorry. Because he does work off his computers, I'd ask to immediately allow one of his brothers, Zach or Adam, to retrieve his computers and then return with the sheriff for a later date to return his other items.
So Ms. Melnick, you're asking to go twice?
One is just for the immediate, because he does work off his computers. He works from home. He does not work in an office. I understand that that might be an option, that he may not return there, but could he have his brothers just at least pick up his computers so he can continue working?
My question is, can he get all his stuff at once? I think that would be best, so that we're not continuing to have this interaction with the victim.
And I do understand that, Your Honor. It's just he immediately needs the computers, and I did not know if he can immediately get all of his items and get it in one item, and I didn't know how long, since it's a holiday week, I didn't know how long it would take the sheriff to get it. But it is an immediate need to have those computers and we're just asking for one of his brothers just to pick up the computers, nothing else. They can leave them outside the front door. He just needs the computers.
All
I
right.
know normally it's a different situation, but this is sort of an unusual situation because he does need them for work.
Understood. I'm not sure how we're gonna address that. I still think that he needs to go there once and get all his stuff.
I do
really
understand.
do.
And I do understand that normally I agree with that. It's just in this one situation, can you just have a brother pick up a computer? They are going through a divorce. We are asking for a signature bond since this is the first crime of this type. But I didn't know how long it would take the sheriff to get there. And it is an immediate need for the computers.
Are they towers or laptops or what is this? Do you know, Ms. Melnick?
Could I ask my client?
Yeah, ask your client.
Just
very
only
quickly.
about the computers, not anything else.
I understand.
There's a MacBook Pro and there's a laptop that I could work off of as well. But I need both of them.
Okay, well, I'm gonna think about that. Is the victim? Let's sound for the victim. Is the victim, alleged victim, on the line? Miss Allison? Is Miss Allison present? All right, hearing none. All right, defendants, go ahead.
And just one more thing. There was a phone thrown. There was not any other type of harm to the person. And I do think that differentiates this type of case. And I don't think it's unreasonable, just considering he does work for Scientific Games and the laptops. And I don't know how long it would take for the sheriff to get there. And I know I'd never ask this normally. You've gone in front of me several times. It's just, I think this was just a unusual request. And I don't think it's an unreasonable one. Thank you.
All right, at this time, defendant's gonna receive a $2,000 signature bond through the jail. He is to have no contact whatsoever with Miss Allison. He's to have no further violent contact, I apologize, with Miss Allison, and he must stay away from the address on Timberland Place. He can arrange transport of the laptops through a third party. Never said that before. And he can return one time to the stay away address with a member of law enforcement to get any other items. And he is to have no alcohol, drugs, or weapons.
Thank you,
All
Your
right.
Honor.
Anything further?
Nothing from the state, Your Honor.
No, Your
All
Honor,
right.
I'm sorry for that special request, but Thank
It's all right. We keep moving, Ms. Melton. Take care. Best of luck to you, Mr. Allison. Who do we have next?
Position 2, Brewer.
All right. Good afternoon, Mr. Brewer. Your case is 22 CR 008534B. You're charged with committing certain prohibited acts in a bus station or rail station and criminal trespass with the offense date of December the 27th. Do you understand your rights?
Ma'am, yes, ma'am.
All right. Thank you. Mr. Howard?
He's on probation. He got 51 total. On probation.
51? You said 51?
Yes.
Okay.
On probation for burglary. 2012, they gave him 5 years to serve, 15 years probation. That's 11 SC 105143. On probation in state court for public drunk. 22 CR 001794B. You want more?
Can you, any criminal trespass in the past 4 or 5 years?
Let's take a peek. July. Trespass on Martin. May.
Okay,
Trespass on Martin.
that's
March.
good. That's good. That's what I wanted to know. All right, Ms. Dowry.
Yes, Your Honor. This incident took place at MARTA, located at 30 Alabama Street. The defendant was seen conducting a hand-to-hand transaction sale of vodka to another person. And when he was asked to leave the property, he refused. He was then taken into custody. And when his name was ran through the system, it revealed that he had an active suspension from MARTA that was not up until May of next year. And he also had an active warrant out of DeKalb. As we've heard from pretrial regarding the history, there are 51 cycles. He does present a risk of reoffending. His last arrest at MARTA was that July. That case is actually still open. He FTA'd on that case, and in that case, he received a $2,000 signature bond through the jail by Judge Morrow in a stay away. Yet here he is again about 5 months later with another criminal trespass charge. The state's recommendation in this case is a $4,000 surety bond. That's $2,000 on each count, a stay away, no drugs, alcohol, or weapons.
Okay, thank you. Ms. Melnick?
Yes, Your Honor, my client lives with his mother in Ellenwood, Georgia at 4281 Cedar Valley Lane. The selling of the alcohol, I think, is a stretch. I think they were drinking on the property, but needless to say, I don't think that case will stick. We are asking, he is indigent, any type of bond or any type of surety bond or a good bond will basically be a no bond in effect for Mr. Brewer.
Okay, all right. At this time, the defendant's gonna receive $1,000 split bond. It'll be $1,000, I'm sorry, it'll be 500 signature through the jail for count 1 and a $500 surety bond for the criminal trespass. He's to comply with all active MARTA suspensions and have no alcohol, drugs, or weapons. Anything further?
Nothing from the state.
All right, best of luck to you, Mr. Brewer. Who do we have next?
Position 3, Dawson.
All right, good afternoon, Mr. Dawson. Your case is 22 CR 008536F. In this case, you're charged with loitering, prowling, and criminal trespass with the offense date of August the 2nd of 2022. Do you know you're right? Do you understand you're right?
Yes, ma'am.
All right, Mr. Howard.
So we did need Dawson?
Apparently we did.
He has 2 cases, 2, 3, and 4.
That's
Oh,
correct.
okay. And number 4, I apologize. Case 22 CR 008538F. You're charged with theft, theft by shoplifting with the offense date of September the 7th. I'm assuming you still understand your rights.
Yes,
You
ma'am.
understand your rights? You have 2 cases.
Good afternoon, Judge Howard. This is Mr. Walker. So Mr. Howard asked if we still needed Mr. Dawson because he was wrongfully added to this calendar. He's already had a first appearance and he should have been placed on the SAP calendar and not the C calendar.
Okay, so he, when was his first appearance? Yesterday?
No.
No, Your Honor, that was on December 16th in
And-
South Fulton's municipal court.
Oh, okay, I think I did see that email. Okay. So, Mr. Dawson, your case has been addressed already. You've had a first appearance before a judge. So what will happen is you'll be reset to the SAP calendar. Is he reset to tomorrow's SAP calendar? What SAP is he reset to? Do you know, Mr. Walker?
I don't think he's been a reset. I don't know if Mr. Jordan wants to make that accommodation, but there'll be no objection from the state because I understand he has been in custody for about 11 days. So
Okay,
if
and he
the
has,
clerk can, yeah, he has $1,000 bond on each
on
count.
each count.
Yeah,
Okay.
so a total of 3,000 for both cases in total.
Okay.
I don't know, what's the earliest we can get him on an add-on calendar if Mr. Jordan wants to make that accommodation for tomorrow. We have
Okay.
reviewed
I
his
doubt very
cases.
seriously if they're gonna do it for tomorrow. That calendar has already been prepared. I think the earliest that they would do it will be on the 3rd, because I did add cases yesterday on the 3rd's calendar, and I still don't know whether or not that's an option.
All right. We don't know where you will be reset, Mr. Dawson. You currently have a bond. So if you have family members who are able to assist you with bond, you will be able to bond out of the Fulton County Jail. However, there is not yet a calendar for your case to be readdressed at this time, but you will be reset to a state all-purpose calendar whereby your case will be revisited. We just do not have a date yet. I will check with the clerk after this proceeding to see how soon we can get you on one, okay?
Your Honor, just so that he's not lingering in the jail, could we at least set January 10th if we can't get him one sooner? At least there will be a date.
I don't
Yes.
think, I think that there will be no objection to that. So let's say for now, You will be reset to the January 10th SAP
Is your
calendar.
honor, sorry to cut you off. Is there way we could do the third? I mean, he has been
No,
in jail
we're
for
gonna
so
put him on the 10th now, Mr. Walker, but I'm gonna
Okay.
try to get him on as early a calendar as I can as soon as
Okay,
we get
thank
off
you.
of this. So we're just resetting him automatically. And then once this is concluded, I'll speak with Mr. Jordan myself. Okay?
Thank you so much. Thank you so
And
much.
let me ask this here. You said that he received a bond on the 16th?
That's correct.
Okay, so it's already been said and done. Just for my record keeping, I just need to know. So
Yes, Ms. Bridgewater.
on
And
that,
They didn't book him incorrectly and put his bonds in the system. That's what caused it.
Okay.
okay, so on position 3, what was the bond on the Loitering and Prowling? I just want to,
1,000 each, Miss Bridgewater.
so
I think.
everything is 1,000 each.
And
Okay,
he has
no
a
problem.
3,000 surety.
No problem. Thank you.
All right, so I will check and see. We'll try to get him in earlier, but at the latest, it will be January 10th.
Okay.
Mr. Walker, I just wanted him to have a date and not have him just slip through the cracks. Not that it was going to happen on any of our watch, but it is, we just want to be safe.
Well, I'm
Understood.
gonna do this here. I'm just gonna stick my neck out there. I'm gonna go ahead and put it on the 3rd.
You done.
Thank you.
Okay, so thank you,
Teamwork
Ms.
makes the dream work.
Bridgewater.
Thank you.
Thank you, Ms.
Always.
Bridgewater.
Okay.
I'm getting lots of favors early.
And
Both
Ms.
of you.
Bridgewater, I am gonna ask this, and I know it might not be possible. I am doing SAP tomorrow. Will you ask and see if that case can be assigned to me tomorrow, if possible? If not, the 3rd is fine.
You know what?
And-
Anything is possible when you believe.
Yes, it is. And so far, Judge, this is Miss Grace and Mr. Walker. We have 48 on the 3rd. So
Ooh.
it may not happen for the 3rd, definitely. It may have to go to the 10th, unfortunately.
Can it, what about
So-
tomorrow, Miss
Tomorrow
Grace?
is a full house too, Judge.
There's no
unfortunately.
objection from the state, so I don't know how many is tomorrow, but if it can happen, it can be done. The state will be prepared, and I'm sure the
prepared
defense will
to
be
sit there
prepared.
I'm prepared for us to be there. You know, I'll be there all day tomorrow. So if possible, Miss Grace, but if not, we will have him put on,
Okay,
we're
we can
all
try
gonna work
for
together.
tomorrow because we have about 35 total plus the competency calendar.
Okay, so if we, and again, I would rather burden myself than someone else.
Okay.
Okay. Consider
if we
it
can-
done.
All right. So Mr.
Okay.
Dawson, we will see you tomorrow at the state all-purpose calendar. All right, who do we have next?
Good afternoon, Your Honor. This is the courtroom 3. The ladies need to hear their rights. And before you is position number 5, Ms. Evans, and she has family in courtroom 2.
All right, Ms. Evans, your case number is 22 CR 008540J. You're charged with 2 counts of battery family violence with the offense date of January the 29th of 2021. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You also have the right to an attorney today at this proceeding. This particular proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can watch it. Ms. Evans, do you understand those rights?
Yes, ma'am.
All right, thank you. All right, Mr. Howard, can I have her history, please?
7 total. Last arrest was for theft by taking. That was the 22nd of this month out of Clayton County. Before that was 2019 probation, given false name. Pled NOLO to 2016. Pled NOLO in 2019, I'm sorry, for a 2016 given false name. So that's where the probation came from. FTA simple battery 2012. 2010 simple battery DV. It was later dismissed in 2012. She had an ag assault, cruelty in the first 2 counts, 2 counts cruelty in the third. No further action anticipated from 06. That's it.
Okay, thank you. Ms. Sowery?
Yes, Your Honor. This incident took place at 565 Greensbury Avenue in Atlanta. Officers responded regarding a dispute call. One of the officers met with the victim, whose name is Harriet, that's Harriett, last name Carthan, and then they spoke on the phone with the other victim, whose name is Tanera, that's Tanera, same last name as the prior victim. Both stated that they were assaulted by the defendant. Ms. Tanera stated that the defendant was moving out of the residence when she became violent and started to push and shove her. She stated that she sustained a bruise on her arm, and then the victim, Ms. Harriet, she tried to de-escalate the situation by standing in between the two, and she was pushed by the defendant and sustained a cut to her left hand. We've heard the history from pretrial, Your Honor. The history does indicate that this defendant presents a risk of reoffending. She has 7 cycles and multiple arrests for violence. She's also a flight risk. She has that 2012 FTA. The state's recommendation in this case is a $6,000 surety bond. That's $3,000 on each count. No contact with the victims, a 1-day anger awareness, stay away, and no drugs, alcohol, or weapons.
All right, thank you. I'm gonna sound for the victims at this time, or the alleged victims. Last name, is it Carton or Cartan, Harriet or Tanera, if they are present on this Zoom conference?
Yes, she's over here in the gallery in courtroom 3, Judge.
Okay, does she wish to make a statement?
Would you like to make a statement, ma'am?
You're not required to.
I'm just here to, she already knew what the part is.
I can't really hear her. Is it a yes or a no?
If you do, then you have to step forward. Okay.
Let him. Well,
Yeah, Sunny? Yeah.
She does wish to make a statement?
Yeah, she does, Judge. She's coming.
Okay.
Just stand right here for me. Stand right here. Hey, good morning.
All right, please raise your right hand and state your name for the record.
My name is Tanera Carthan.
Okay, Ms. Carthan, do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, thank you. Put your hand down. What I am most concerned with is whether you wish to have contact with the defendant.
Yes, I do. She lived in a totally different place from me, but we're siblings, and my mom, she don't want to press charges in me either. It was just a little misunderstanding. However, I called the police so he could defuse the situation, but I don't know where all that came from. And we run her in Clayton County, so it's just my mom want her home with the kids and stuff like that. But I think she's a little better now. So,
Okay, I appreciate you coming to
thank
make that
you.
statement.
Okay.
All right, thank you. All right, Ms. Kim, good to see you. Will you please proceed?
Yes, Miss Evans is 37 years old, Your Honor. She was born and raised here in Georgia, and she has 3 children. The youngest one is 6 years old, so she has to go back to take the minor children. Your Honor, this incident happened about 2 years ago, January 29, 2021. Ever since then, they have been fine. There has not been any other incidents, and they are actually getting along better. They live totally different city. My client lives in Columbus, Georgia right now, while the complaining witness lives totally different place. We would like to request for signature on bond since she's qualified for public defender's service, as she was fired from the chicken plant that she had been working. I believe that she was arrested in police department in Illinois Police maybe 5 or 7 days ago, and then she got transferred to Fulton County yesterday. So we believe she has been in the jail for more than enough. So we would like to request for a signature on bond. Thanks.
How long has she been booked in on this charge? Are
Uh,
you saying that she's been booked in longer than 3 days, Ms. Kim?
I would like to double check with my client. May I please ask her, Miss Evans,
what date were you arrested?
On the
Hold on, say it
21st.
again, say it again.
I was arrested on the 21st in Clayton County.
Okay, so but not necessarily on this charge. Miss Sauer, how long has she been booked in on this particular charges?
Your Honor, I see 2 days.
Okay, okay. All right, thank you. All right, at this time, defendant will receive a $3,000 surety bond, 1,500 on each count. She's to have no further violent contact with either victim and have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further from the state.
All right, best of luck to you, ma'am. Who do we have next?
Position 6, Mr. Gass.
Okay, Mr. Gask, your case number is 22 CR 008541C. In this case, you're charged with destroying, concealing, or encumbering a property subject to a security interest with the offense date of December the 31st of 2020. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
What was that last bond amount?
3,000.
18 total. Last arrest was in July, probation out of the cab. On probation in the cab for ag assault, possession of cocaine. Most of the history is violence. I got a January 2022 possession of a firearm by a convicted felon. It's either drugs or violence in this history. I didn't see
Okay.
anything related to what he's charged with now.
Okay, thank you. Ms.
And your-
Dowry?
Yes, Your Honor. There is one open case. It's from 2019, theft by taking. That case is open and I pulled it, and it's open due to the defendant's failure to appear because he was incarcerated. So the state's position on this is that he does present a risk of reoffending, as we've heard from pretrial. Most of his history is violent. However, it's back to back, 2019, 2020, 2021, 2022. So he does present a risk of reoffending and a risk of flight. We have a 2022 FTA. The facts in this case is that the defendant financed a vehicle at a dealership and promised to pay off his loan by the incident date. The business made several attempts to collect payment, but the defendant did not respond, and it does not appear that the company ever received their vehicle back. The name of the company is Lawson Auto Sales, and that's located at 2664 Donald Lee Hollowell Parkway in Atlanta. Again, due to the history and the risk of reoffending, our recommendation is a $3,000 surety bond, which has already been set. So we are asking for it to remain as set. A stay away, no drugs, alcohol, or weapons, nothing further.
I'm sorry, what, can you give me that stay away address again, Ms. Dowry?
Yes, Your Honor, it's 2664 Donald Lee Hollowell Parkway in Atlanta.
Thank you. Ms. Melnick?
Yes, Your Honor, I do want to highlight some dates here, and normally I'm the first one to say that we're not here to try the case when the state cites their facts, but I do want to highlight a few dates. First of all, the date of purchase of the car was on November the 23rd of 2018. They were supposed to have the car paid off by December 31st, 2020. It wasn't until September of last year that the owner took a warrant out for his arrest for this case. It was in September. And I did notice that when I was looking in Odyssey, the owner never filed a civil case. I think he's just using the courts to go for a civil case as opposed to this. As the state and as pretrial indicated, my client was in jail for the majority of this time. As I said, we're not here to try the facts, but the car was parked in his front yard. And the owner of the company was calling his mother, and the mother kept saying the car's in the front yard. And eventually code enforcement took the car. So he wasn't even home. He was incarcerated majority of the time. We are asking for a signature bond. This is not any type of pattern. I think this is more of a civil case that they're using to get criminal satisfaction on. So we are asking for a signature bond in this random case, just because of the facts is so remote and it's so unusual fact situation.
And Your Honor, I'll just say that the year that it took the dealership to file for the warrant application speaks to the dealership's willingness to work with the defendant and the defendant's lack of response or willingness to turn the vehicle back over to the dealership. And that's why the dealership took the actions that it did.
However, Your Honor, when my client is a state and the pretrial admitted he was in custody for a good portion of that time.
And Your Honor, also, I just wanted to respond regarding this being a civil matter. So our legislators have created a statute, a criminal statute for this matter. So that's why we are proceeding as such.
Okay. I got you.
Facts are the facts. Thank you.
Okay, thank you. I got it. We're gonna write a, I'm gonna order us all to work on that law review article on several different points. All right, defendant is gonna receive $1,000 surety bond. He stay away from the incident location, have no alcohol, drugs, or weapons. All right.
Thank you, Your Honor.
All right, best of luck to you, sir. Who do we have next?
Position number 9, Ms. Lockhart.
Okay, Ms. Lockhart, your case is 22 CR 008543A, in which you're charged with simple battery with the offense date of September the 2nd of 2022. You understand your rights?
Yes.
All right, Mr. Howard, can I have Ms. Lockhart's history, please?
First arrest.
Okay, that's simple. All right, Ms. Dillingham, good to see you.
Good afternoon, Your Honor.
Can I please have state's recommendation?
Yes, Your Honor. It is important that I state the facts for the record. So on September 2nd, 2022, the victims, in this case, Kwanzaa Powell, Kwanzaa Worthy, and their infant 6-month-old child, Yuri Hinton, were in the McDonald's drive-thru at 3670 Cascade Drive Southwest. After Ms. Powell made a complaint about the food, a verbal argument ensued between she and the defendant, who was working at the window, which led to the defendant throwing a cup of ice into the victim's car. The ice hit everyone in the car. And Your Honor, as this case is for simple battery, after speaking with Ms. Powell today, who is unable to be in court due to a family emergency, she did let us know that her child was injured as a result, and her nose was swollen from being hit with the ice.
One question, I'm sorry, and let me get the fact. The defendant was working in the restaurant and the victims were in the vehicle.
Yes, Your Honor, and the defendant
Okay.
was looking in the drive-through window
Okay.
when he threw the ice.
Okay. Okay.
Through the window. So for that reason, we are asking for a $3,000 surety bond on the simple assault or the simple battery, and a $3,000 bond on the battery. And as I mentioned, that was filed later after speaking with the victim. So I'm not sure if it's appearing.
It's not. There's only one charge on this calendar. So they're saying that there should be 2 that have already been.
Yes, Your Honor. The battery was filed a few hours later after speaking with the victim, who notified us of the injury.
Mr. Walker, I saw you on mute. Go ahead.
I was just saying the clerk's office has to pull it down, but we did file it, as Ms. Dillingham just stated.
Okay, so I'll say the chart count 2, there's battery. All right. Thank you.
And
So we have a simple battery and a battery?
Yes, ma'am.
Okay.
And
All right.
additionally, Your Honor, we would ask for a no further contact with the victims.
Okay. All right, thank you. Good afternoon, Ms. McLeod. Please proceed.
Good afternoon, Your Honor. My client is 28 years old. She's never been arrested in her life. She's never been in any trouble whatsoever with the law. She is the mother of 4 children, 12, 9, a 2-year-old, and I believe a 5-year-old. And she is the primary caregiver for these 4 children. She absolutely denies the state's version of the facts. In fact, what she tells me was that she was working as a cashier at the McDonald's in Cascade when this couple were extremely rude to her because she asked them to confirm what exactly they had they had ordered. They called her out of her name, and she decided, she asked her supervisor to get someone else to deal with them. And they actually came into the restaurant and threatened her. So what the state is saying is not what happened. They actually came into the restaurant and threatened her, Your Honor. These are strangers to her. So she doesn't know them. So we don't have a problem with a stay away. Also, the fact that the state has just sprung this new charge on us, it wasn't there when I spoke with my client. She doesn't know that this is being alleged. She denies that that is what happened, Your Honor. And she says those people actually threatened her and were exceedingly rude to her. She doesn't have any history, Your Honor. So I would ask the court to give her a signature bond so she can get out of jail to take care of her 4 children who need her. Also, this incident allegedly happened in September, I believe, Your Honor. And she definitely hasn't contacted them because she has no contact information for them or any interest in contacting these people who threatened her. Nothing further, Your Honor.
All right, at this time, the defendant is going to receive a $3,000 signature bond through pretrial services, $1,500 on each count. She's to take the 1-day anger awareness course and have no further contact with any of the alleged victims. Furthermore, she's to have no alcohol, drugs, or weapons. Is there anything further?
Nothing further, Your Honor.
All right, best of luck to you, Ms. Lockhart. Who do we have next?
Position 7, Jones.
All right, good afternoon, Mr. Jones. Your case 22 CR 008545J. In this case, you're charged with criminal trespass and 2 counts of willful obstruction, each with the offense date of December the 27th. Do you understand your rights?
You gotta speak up, Mr. Jones.
Yes, all right, thank you. Mr. Howard, can I have his history?
33 total. You got history out of Alabama, Texas, Oregon, and Oklahoma.
Criminal trespass in the past 5 years?
Last arrest was in January for trespass. That case number is 22 CR 000038D. I think the balance of that was suspended. Also has an open misdemeanor possession of marijuana. Hold on. I'll give you the Georgia history first.
Okay.
April 2021, that's the marijuana charge. 2018 trespass PI. What else? Paid to appear. Got a obstruction conviction. 2017 trespass. 2017 trespass dismissed. 2016 obstruction trespass. Those charges
I
were.
think that's good, Mr. Howard.
Hold on, Ian. I gotta let the judge gotta tell me that now. He ain't said nothing.
I'm still writing. Writing. Give me a little more. Keep going.
You said keep going or wait?
Yeah, keep going.
Oh, well, that's it with the Georgia history. Let me go out of state real quick. I mean, he got more in Georgia, but that's real old.
Okay, thank you. Ms. Sowery?
Yes, Your Honor. This incident took place at Barnes & Noble and it's located at 2900 Peachtree Road in Atlanta. The defendant was told to leave the incident location and refused, and he had been previously trespassed from the entire complex. While he was being arrested, he balled up his fist in an effort to prevent the officer from arresting him, and then the defendant attempted to flee on foot. We've heard that Georgia history from pretrial. Almost every year since 2017, the defendant has been convicted of criminal trespass. There's a $3,000 surety bond currently set. We are asking for that bond to remain as set due to his risk of reoffending, a stay away from the incident location, and no drugs, alcohol, or weapons.
All right, thank you. Ms. Kim?
Yes, Your Honor. Mr. Jones is 48 years old and he has been here in Georgia quite a bit. He does not exactly remember how long. Your Honor, he has been residentially challenged. So we would like to request for social worker services to provide housing resources for him. And also maybe they can have a behavioral health evaluation to determine whether he needs a competency calendar more than SAP calendar. At this point, we would like to request for either signature on bond or maximum $1,000 good bond. He has not had any employment. He has no benefits. He does not have any resources to pay for a bond. So even $250 bond will be a no bond to him at this point. Thanks.
All right, at this time, defendant is going to receive a $3,000 split bond, 1,000 surety on count 1, and 1,000 signature on each remaining count through the jail. He is to stay away from the incident location on Peachtree Road and have no alcohol, drugs, or weapons. And Ms. Kim, will you make sure that a social worker does come and see Mr. Jones?
Yes.
All right. Best of luck to you, Mr. Jones. That concludes your case.
Position 11, Ms. Reddick.
All right. Good afternoon, Ms. Reddick. Your case 22 CR 008532F. In this case, you're charged with battery with the offense date of December the 27th. Do you understand your rights?
Yes.
All right, Mr. Howard.
My file says first arrest.
Okay, thank you. Ms. Dillingham.
Yes, Your Honor. So on December 27th, 2022, officers responded to the victim's residence, the victim Kiara Harris. This residence is located at 703 Cimarron Parkway. Ms. Harris lives there with her boyfriend, who is also the ex-boyfriend of the defendant. A argument ensued between the defendant and the victim's boyfriend, which led to a physical altercation where the defendant punched Ms. Harris repeatedly, causing her to bleed in her nose, her lip, and her hand. For that reason, we are asking for a $3,000 surety bond, a stay away order from that location, no further contact with Ms. Harris, and also 1-day anger awareness.
Okay, I'm going to sound for Ms. Harris at this time. If Ms. Harris, you're present on this Zoom conference and wish to make a statement, this is your opportunity to do so. All right, hearing none, Ms. Kim.
Yes, Your Honor. Ms. Reddick is actually, she was born 1996, so 26 years old. And Your Honor, she has never ever had any kind of trouble with the law. She has been a very good student/worker. She is currently going to school, University of Phoenix, to study business management while she's also working as a model part-time. And also she has a 4-year-old son that she has to take care of. She's qualified for public defender's service, so we will be continuously representing her and ask her to help her to prove her innocence. She was actually, her neck was choked by ex-boyfriend, and she was trying to untangle and get out of that situation. However, the boyfriend and his new girlfriend have all the nice story that they collaborated, and my client is basically accused all by herself. And we would like to request for signature on bond because that is not what happened, and my client was defending herself. Thanks.
All right, defendant will receive a $3,000 signature bond through pretrial. She's to take the 1-day anger awareness course, have no contact with the alleged victim, last name Harris, stay away from the address on Cimarron Parkway, and have no alcohol, drugs, or weapons. Is there anything further?
Nothing further.
Nothing from the
All right.
Is that
Jessica?
pre-trial, Your Honor?
Yes.
Pre-trial. Okay, thank you.
All right, who do we have next?
Position 8, Kimbrough.
All right, good afternoon, Mr. Kimbrough. Your case 22 CR 008542A. In this case, you're charged with battery, family violence, and criminal trespass, each with the offense date of December the 27th. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
5th arrest. My notes say he's on probation, federal probation, robbery by force or violence, conspiracy to defraud the United States. Got a 2012 felony obstruction arrest, along with a battery, 2016 burglary, 2017 entering auto, and that was amended to trespass conviction. That's it.
Okay, thank you, Ms. Sowery.
Yes, Your Honor. This incident took place at the Franciscan Club Apartments that's located at 1935 Allison Court in Atlanta. Officers responded and spoke with the victim, whose name is Kiana Ridley, and that's spelled Keanna, last name Ridley. They spoke with the victim, who stated that she and the defendant were arguing inside of her vehicle when he pulled her hair and actually yanked out a few of her braids that were attached to her head. The victim then pulled her car over and tried to seek help from a Grady EMS vehicle that was parked in the area. And when the defendant saw the victim seeking help, he started to grab at her and pull the steering wheel. He eventually got out of the car and the victim pulled off. And of course, the victim reported this incident. And when the officer left the location to prepare the report for the battery, they received another call from the victim stating that the defendant came to her house, banging on her door, and actually busted out a window in her apartment. We have heard the history regarding the robbery. That was a robbery of a bank by force, guilty conviction. He is on probation for that, and that was out of Alabama. So he does present a risk of reoffending in a multi-state offender. That battery out of our jurisdiction, that was a guilty plea in exchange for a pretrial intervention program. So he did complete that. However, he is here today for another violent offense. The state's recommendation is a $4,000 surety bond. That's $3,000 on the battery family violence and $1,000 on the damage to property. No contact with the victim, a stay away, 1-day anger awareness, third-party transfer of their minor child, and no drugs, alcohol, or weapons. And Your Honor, the victim is on the call if you may sound for her.
All right, I'm sounding now for Ms. Ridley. Ms. Ridley, if you wish to make a statement. Ms. Ridley, is she present? All right, I'm assuming she does not wish to make one. We will go to Ms. Kim.
Yes, Your Honor, Mr. Kimbrough is 27 years old.
I'm sorry, I couldn't unmute.
Okay, Ms. Ridley, if you want to make a statement, we also need you to turn on your camera so we can identify you.
Is it on?
It is. All right, if you'd like to make a statement, I need you to raise your right hand so I can place you under oath. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. I'll hear what you like to tell me, but what I'm most concerned with is whether you wish to have contact with the defendant in this case. What would you like to tell the court at this time?
The night that it happened, I think that he got hooked into some bad drugs or whatnot because it never happened before. And far as him being around me, we got that clear that he won't be around me due to the damages that he did cause. And yes, that's all I have to say.
All right. Thank you, Ms. Ridley. I appreciate you making that statement. Ms. Kim?
Yes, Your Honor, Mr. Kimbrough is 27 years old and he has 4 children. They're all minors, and he has a 1-year-old child with a complaining witness. They were living together. However, my client already moved out and he has no objection to stay away and no further contact. Indeed, that's what he wants. And also he's gainfully employed at Keys Paving. He pours concrete and asphalt. So he does want to go back to his job. He has to go back by next Monday after the holiday break. So he would like to get out of the jail to be there. and be more productive citizen instead of being in the jail. We would like to request for a signature on bond. And yet, if Your Honor is not inclined to give him a signature on bond because of the past histories, we would like to request for maximum $1,000 good bond, 500 each. Thank you.
All right, at this time, defendant is gonna receive a $2,500 surety bond, 1,500 on count one, 1,000 on count two. He's to have no contact whatsoever with the alleged victim, last name Ridley, and stay away from the location on Allison Court. He can return one time with a member of law enforcement to get any items, and he can arrange to transport his children by conversing with a third party. Moreover, he's to have no alcohol, drugs, or weapons. Is there anything further?
Nothing further, Your Honor.
Nothing from the state.
All right, best of luck to you, Mr. Kimbrough. Who do we have next?
Position 13, Ms. Thompson.
All right, good afternoon, Ms. Thompson. Your case is 22 CR 008537J. In this case, you're charged with fair evasion, obstruction, and tampering with the evidence, each with the offense date of December the 27th. You understand your rights?
Yes, ma'am.
All right, Mr. Howard, can I have the history, please?
First arrest.
Okay, thank you. Ms. Dillingham.
Yes, Your Honor. So the defendant was at the MARTA station at 300 Main Street, College Park on December 27th. The defendant was there with two other individuals who were also arrested. In this case, during the arrest, after not paying the fare to enter, one of the co-defendant's guns came out of his coat pocket, and the defendant took the gun to try to conceal it from officers on the scene by putting it under her shirt. And for this reason, we are recommending a $3,000 surety bond and a stay away order from 300 Main Street. And Your Honor, it is important to let you know that the other two individuals in this case, their cases have been sent up to the DA's office, and we have recommended this one to the DA's office as well.
Okay, thank you. Ms. McLeod?
Yes, Your Honor. My client is 18 years old. She is currently employed. She works at the airport, she tells me, Your Honor. She denies that the facts stated by the prosecutors what happened. She tells me that she was at the MARTA station with her younger brother and also someone who's a good friend of her brother's, and they were on the train when they were approached by some men, a man and a woman actually, who claimed that they were MARTA police. She said they were taken into some room and she was touched inappropriately by the male. Even though she protested what he was doing, there was a woman there, nobody stopped him. She was searched in a manner that she thought was inappropriate for a male to do when there was a woman present who could have done it. So she's pretty upset about that, Your Honor. I would ask the court to give my client a signature bond. She does not have any criminal history whatsoever. And also, Your Honor, what she tells me is that the gun was just, the other person just kind of pushed the gun at her. She really didn't know what was happening. It all happened so fast. And she was totally unaware that he had a gun.
All right. At this time, defendant's going to receive a $4,000 split bond. It'll be a $1,000 signature through the jail for fair evasion, a $1,000 signature through the jail for the willful obstruction, and a $2,000 surety bond for the tampering with the evidence. She stay away from the College Park train station and have no alcohol, drugs, or weapons. Is there anything further?
Judge, on that charge number 3, that's a good bond. You said it's going to be a split bond?
Yeah, good number.
Okay.
Charge 3 is good. The other 2 are signatures.
For the jail. Yes, ma'am. Thank you.
Thank you. Now I see, Mr. Jordan, I see the note in the chat Going back to Dawson briefly. Let's see. How do we fix that, Mr. Jordan?
So the issue is he did receive a first appearance at the city of Atlanta. I'm sorry, city of South Fulton. But they assigned a total bond of $3,000. But he has two separate incidents. He has a loitering and prowling and criminal trespass charge with the incident date of 8/2/22. And then he also has a death by shoplifting case with the incident date of 9/7/22. So they just need
Can I change it?
a
Just
bond
make it
amount to assign to the two separate cases.
okay, so can I make it the 2,000 for position 3 will be 1,000 for each charge, and then for position 4 it'll just be 1,000 surety, so that equals that same 3,000 and fixes that issue.
That'll resolve it.
And no objection from the state.
All right. All right. Best of luck to Ms. Thompson. All right, who do we have next?
And let me ask also, since Mr. Jordan is on the line, can we reset this to Thursday? Can you put it on the add-on calendar for Thursday, tomorrow?
He'll be fine as long as he's getting that bond.
Okay, well, there you have it, Judge. It'll be placed on their calendar.
Okay, thank you. All right, who do we have next?
Position 10, McKeever.
All right, good afternoon, Mr. McKeever. Your case is 22 CR 008546G. In this case, you're charged with simple assault, family violence, with the offense date of December the 26th. Do you understand your rights?
Yes, ma'am.
All right, thank you, Mr. Howard.
17 total.
Turner.
Last arrest was back in July, sale of marijuana out of Henry County. He's out on pretrial for 2022 case. 22 CP 206978. Possession of a controlled substance with intent. Possession of marijuana with intent. Possession of drug-related object. I see any violence. He had a March arrest probation violation, 2018 probation, 2012 probation. He don't have any violence in the last 10 years, I know.
Okay, thank you. All right, Ms. Dillingham.
Yes, Your Honor. So this incident occurred on December 26th at the victim's residence, 4235 in Kauai. The victim, Travius Rivers, lives at that residence with her mother. The defendant is her mother's ex-boyfriend, who also used to live at the residence. So he was not welcome back at the residence at the time. On this day, he entered the residence and got into a verbal argument, which led to an altercation with Miss Rivers' mother. He charged at Miss Rivers, putting her in imminent fear of harm. And as a result, we are asking for a $2,500 surety bond, a stay away order from that address, 4235 in Kauai, and a no further contact with Miss Rivers, Travius Rivers.
Okay, I see a Veronica Rivers on the line. Is Miss Travius Rivers on the line as well?
I don't believe Miss.
I see someone connected.
There was someone in the break.
I see someone coming on.
Okay.
All right, are you Travius Rivers? I'm not sure if I'm saying that correctly. Are you present on this Zoom conference? And do you wish to make a statement? Okay, it's unclear. All right.
I don't believe it's her, Your Honor.
I don't believe so either. Ms. Rivers, I understand that you may want to make a statement today, but what I typically do is I'm going to hear from the victim exclusively. All right, so we're going to go ahead and go to Ms. Kim. Ms.
Yes.
Kim, please give me the defense's position.
Yes, Your Honor. Mr. Mr. McKeever is 34 years old and he has been gainfully employed here in Georgia. He works at a construction company to do a shipping and receiving. He has not had any violence case before, and this is something that there was no violence actually. This is something that he believes the daughter, ex-girlfriend's daughter is somehow not really happy about it. We would like to request for signature on bond for this case. If Your Honor is not inclined to give him a signature on bond, we would like to request for maximum $1,000 good bond. Thanks.
All right, Ms. Rivers, I'll hear from you very briefly. What would you like to tell the court? Please unmute.
Travius Rivers is here. I'm sorry.
Okay, please turn on your camera.
Which one you want, me or Travius?
Travius, please.
It's my house, though, Judge. She doesn't.
Okay, I'll hear from you. Give me a moment. Ms. Travius Rivers, please unmute.
Hi.
All right, please raise your right hand if you'd like to make a statement. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. What would you like to tell me?
Well, I wanted to state first that this isn't the first incident of Mr. McIver being violent towards my mother, and also what they failed to mention also was that a child was present. 2 children were present. One being my child, who's a 11-month-old, and the other one being my niece, who is 11 years old. And he physically attacked my mother while she was holding my 11-month-old baby this time. The last time
Is it safe to assume, Ms. Rivers, that neither you nor your mother wished for the defendant to have any contact with you or to return?
For me, it's safe to say for me. I can't speak for my mom because, you know, she has her own feelings about him.
Okay. All right, Ms. Rivers, Ms. Veronica Rivers, I will hear from you very briefly. Please unmute and raise your right hand. Do you swear and affirm? Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge?
I do.
All right. What would you like to tell the court? Very briefly.
It's my home. He lives with me. His clothes are there. He's not my ex-boyfriend. We did have a time we weren't together, but we were back together. He has access to the home. He willingly come and go as he please. So I can't have my child telling me who and who cannot live with me or who I can date.
Okay.
And she's an adult. She's a grown adult.
All right. Thank you. Ms.
Your Honor,
Daniel.
if I may.
Yes, go ahead, Ms. Daniel.
The fact that Miss Veronica Rivers, the mother, is still in a relationship with the defendant has no relevance to the fact that the victim in this case, Miss Travius Rivers, is still frightened by the defendant and that he attacked her.
The court understands that. Miss Travius Rivers, do you live with your mother?
I was, but even though my mother's being abused, she's, as you guys can see, is standing strong in her relationship with Mr. McIver. So at this point, I have removed my child and I from the residence because I don't feel safe. Again, she's saying he lives with her now, but that changes weekly. She kicks him out. He's kicked our door in. He's broken into our home. So at this point, for my safety, I'm gone.
You don't live there though. That's the
not
part
as of the incident. No, not anymore.
Okay. So here's what we're gonna do. Because your mother is not the alleged victim in this case, there's not much I can do, but I will order that he has no contact with you. All right, defendant is going to receive a $3,000 surety bond. He's to have absolutely no contact whatsoever with Ms. Travius Rivers. I'm not going to order this stay away based upon the information that Ms. Travius Rivers does not live at that residence anymore. And moreover, he's to have no alcohol, drugs, or weapons. Is there anything further?
Your Honor, sorry, I dropped off, but does Ms. Rivers have a child that was present for the incident or no?
I do.
And that's what she does. Yeah.
Can we have a stay away or no contact with the juvenile as well?
Well, no, she's certified. We will add the child for the no further contact, Mr. Walker, but Ms. Travius Rivers has informed the court she no longer lives there. She
right, I
has
understand.
herself.
Yeah, I understand. I just think that the juvenile was, I could be wrong, but I thought the juvenile was present.
She was on both incidents, on every occasion.
No further contact. What, Ms. Rivers, will you give me your daughter's or your child's initials only?
NR.
All right, and no further contact with the juvenile NR as well. All right.
Thank you.
All right, that I believe that will.
How much was that?
conclude this case. It was 3,000.
Thank you.
All right, best of luck to you, Mr. McKibber. Who do we have next?
I'm sorry, Judge, position 14, Turner.
All right, good afternoon, Mr. Turner. The case is 22 CR 008539B. In this case, you're charged with willful obstruction with the offense date of December the 27th. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
First.
All right. I'm sorry, Ms. Dillingham.
Yes, Your Honor. This case occurred on December 27th, 2022. Officers were investigating an armed robbery when they approached the defendant and he fled. For that reason, we are asking for a $2,000 surety bond, a stay away order from 152 Ruzel Drive Southeast, which is where he was apprehended.
All right. I'm sorry, and can you give me that bond amount again, Ms. Dillingham?
A $2,000 surety bond, Your Honor.
All right, thank you, Ms. Kim.
Yes, Your Honor. Mr. Turner is 18 years old. He is indeed senior in high school, South Atlanta High School. He's expecting to graduate May 2023. He gets A's and B's and C's. Even though he has a learning disability, he overcomes his difficulties to excel at the school. And also, Your Honor, he played football to the point that he was a state champion. His team actually won the state champion when he was playing. We would like to request for signature on bond. His mother is willing to co-sign so he can come home. Mother Tawana Turner, I believe she was gonna be there at the courts. But I was able to speak to her and she's willing to co-sign. Your Honor, he's 18. I believe this is first one. There's no indication that he is actually related to that armed robbery. He was scared of officer. I mean, who would not be? He's only 18, Your Honor. We would like to request for signature on bond. Thanks.
All right, defendant will receive a $3,000 signature bond through the jail. He is to stay away from that incident location and have no alcohol, drugs, or weapons. Is there anything further?
Nothing further, Your Honor. Thank you.
All right, best of luck to you, sir.
All right, thank you.
All right, who do we have next?
15, Williams.
All right, good afternoon, Mr. Williams. Your case 22 CR 008544A. In this case, you're charged with battery with the offense date of December the 27th. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
38 total.
Violence in the last 5 years?
He mostly got drugs in his history. He's on probation, possession of cocaine with intent, 17 SC 155793. Let me see if I can find some violence.
Well, if you don't see it, let's not look for it.
Well, I gotta search through the file. I ain't gonna
Alright.
make nothing up now. I'm just saying. I don't see any within the last 7 years.
Okay.
I don't think he mostly got drugs in his history.
Okay. Ms. Dillingham.
Yes, Your Honor. This incident occurred on December 27th when officers responded to the victim, Kenneth Harris's residence located at 500 McDaniel Street Southwest. The defendant was staying with Mr. Harris for a short period of time due to the fact that he is homeless. And one of those nights where he was staying, they had a verbal argument, which resulted in defendant punching Mr. Harris in the eye. The officers, when they arrived, they did observe a laceration above his left eye. And so because of the criminal history, as stated, we are going to ask for a $2,500 surety bond and no further contact with Mr. Harris. Also a stay away order from Mr. Harris's residence, 500 McDaniel Street Southwest.
All right, thank you, Ms. McLeod.
Yes, Your Honor. My client is 40 years old. He is a native of Atlanta. He tells me that he works from time to time in construction. Your Honor, he tells me that this incident was purely accidental. He said he was talking to his friend, and he tells me that they actually know each other quite well and they're good friends. They were just talking, and he was moving his hands around, and the alleged victim, the hands, he was coming towards him and his hand hit him. And he told the officers that on the scene. His friend was a little bit upset, but he did apologize to his friend and explain what happened, Your Honor. As the pretrial has said, he doesn't have any history of violence at all, and he had no intention of being violent on this occasion. This was purely an accident. Your Honor, he doesn't have any money to post bond. He doesn't have a problem staying away from the alleged victim if that is what he wants. I would ask the court to give him a signature bond. I know he does have some history, but as pretrial pointed out, his history is not violent. And he doesn't even have a home right now, Your Honor.
All right, defendant will receive $1,000 surety bond. He is to stay away from the address on McDaniel Street. I am going to sound for the victim, the alleged victim, last name Harris, at this time. All right, and he's to have no contact with the alleged victim, last name Harris, and have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further from the state, Your Honor.
All right, best of luck to you, Mr. Williams. Who do we have next?
Judge, I have a quick announcement. Go ahead and have a seat. For position number
12.
I believe that's it. Yes, position number 12 is going to be a medical reset for tomorrow.
Okay.
And we are completed here in courtroom 2, Judge.
All right, we've completed the entire calendar. Ms. Bridgewater, would you please review for me?
Thank you.
Yes, Your Honor. Once again, the reset date for the SAP calendar is going to be January the 10th. Position number 1 is reset further notice with a $2,000 SOB through the jail. Position 2 is reset to the SAP calendar with a total $1,000 split bond. Position 3 and 4 are being reset to the SAP calendar for tomorrow. Position 5 is going to the SAP calendar January the 10th with a $3,000 total good bond. Position 6 SAP calendar with the $1,000 good bond. Position 7 SAP calendar with the $3,000 total split bond. Position 8 SAP calendar with a $2,500 total good bond. Position 9 has 2 charges. In addition to the simple battery that was on the calendar, there is a battery charge added, and it's reset further notice with a total $3,000 SOB through pretrial. Position 10 is going to the SAP calendar with a $3,000 good bond. 11 reset further notice with a $3,000 SOB through pretrial. Position 12 is medically reset till tomorrow. Position 13 is going to the SAP calendar with a total $4,000 split bond. Position 14 reset further notice with a $3,000 SOB through the jail. And position 15 is going to the SAP calendar with a $1,000 good bond. Are there any questions, comments, or otherwise?
Yeah, what was 3 and 4?
Position number 3.
Oh no,
and
they're going
4,
to SAP, right?
yeah, they're going to the SAP calendar for tomorrow. Okay?
All right, hearing none, we will be in recess until tomorrow's SCA calendar, at which time I will be presiding. So I'll see all of you all tomorrow. Take
Your Honor,
care.
I don't think I'll see you the rest of the week, but if I don't, have a happy new year, okay?
You too. Happy New
Same
Year
to
to
everyone.
those I
Thank you.
won't see.
Yes, everybody else too.
All right.
Take
Be
care,
safe,
you guys.
be healthy.
Most importantly.
Yes.
Thank you.
Take care.
Bye-bye.
Holly.